Well, welcome aboard, everyone. We are the 3 gigs minus 1. So this is Craig, I'm Paul, and that's not Jim. He's not here today.
We're short a gig.
All right. 3 guys in glasses, and we're here to help you understand some of the terminologies of construction. Craig always represents the owner's perspective. I always represent the subcontractor perspective. And Jim, who is not with us today, represents the general contractor. It's a good thing he's not here today.
Really?
Because we are talking about flow down provisions.
This is where we're going to make the GC a piñata.
Yeah, that's exactly right. So anything that we can pin on to the general contractor, we will. We'll try to hold him as responsible as possible in his absence. So, Craig, there's this thing known as a flow down provision in a contract, or a flow through, or a conduit, or a pass through clause. What are those all about? Why would you as the owner find it necessary to send something down to the general contractor and make it clear that he is supposed to pass that on to the subcontracting community?
Good question. Basically because I don't trust the general contractor to be competent at their job.
I wasn't expecting that.
I know, you were looking for a higher brow perspective.
But no, I get it. That's good.
Don't trust the contractor to do the right thing. There's some important things that we have established with the general contractor. Performance, labor, cleanup, certainly communication, when and how to communicate. We understand that they're not doing any of the work. It's their subcontractors who are doing the work. And this desire and intent, if the subcontractors aren't on board with it, it isn't going to happen. So if we really think that these are some important elements, then we want to make sure that they flow to the subs, and our only control is to put it in the agreement with the contract, the GC, and then we see what happens.
Exactly. So I think the problem begins when we actually read the clauses, and it seems to be very broad-based. It's a big broad brush that has been applied to it. For example, a clause might say something like, to the same extent that the general contractor is bound to the owner to build this building, so is a subcontractor.
Right.
And that is obviously not the intent of it, I don't believe, but that's the language that we would see in our subcontracts.
Right. And personally, I think that's a lazy contract, and or whoever created the original draft, an attorney or somebody else, they didn't understand construction and the real firewalls that occur in the construction process between all the trades. A better contract will throw a broad net, but it acknowledges that only within the realm of what that subcontractor is in direct control of.
So within the scope of their work.
Right.
So I can buy that, but I believe then that I would want to see very specific language about that in my contract.
If I were a sub, I would want to.
Right. I'm not interested in some kind of ambiguous language that could mean in a court of law that I failed to build the owner's building for them and therefore I'm responsible for it. Right. So some of the things that are typically included in these flow down provisions would be, I think you mentioned a few, but for the most part it would be payment terms and timelines, performance standards and deadlines, timing issues, liability, indemnity, so our insurance requirements. And I think most subcontractors would be on board with that. Whatever the owner requires of the general contractor, the subcontractor must also have in terms of their umbrella, workers' comp, all those things.
That one's not hard.
Right. Labor compliance, so certain federal law that would have to be included in any construction contract. I think the subcontractor would expect that would come down to them. Things like prevailing wages, right? So on and so forth. Can you think of anything else?
No, but within that one of performance standards, that one can be kind of broad. It could be what we would think of in terms of means and methods and materials and labor and performance.
Right. So basically following the specs.
Right. What I'm worried about as an owner is communication. And so to the extent that I've got language in my contract with the contractor that says, you've got 15 days to notify me of something when you become aware of it, if it's going to impact the schedule or the cost. And if you don't do that within 15 days, you have waived the ability to bring that forward as a request or a claim. I want that in the subcontract.
Now, see, and I don't, which means I want to try to negotiate that a little better.
Right.
I want some real, if I'm going to accept that as a sub, I want that so tight. I want the language about that so tight that I'm only accepting the risk that I am able to accept. I mean, you know the old adage, who should accept the risk in a construction contract?
Right.
If I ask that question in a training group, for example, you'll be surprised how many people will just automatically, it's a ripple through the crowd, they'll say the owner. Right, it's their project.
Right.
They should accept the risk.
Right.
But then I'll say, wait a minute. What's the contract all about? The owner isn't building their own project. That's why they hired a general contractor.
That's it.
So the owner did everything that they could to pass all the risk to Jim, who is not here.
Right.
He's going to accept all the risk, and. But the real answer to that question is, who should absorb the risk in a construction contract is the party that can accept that risk with the minimum amount of negative impact.
Right.
So some of that risk should stay with you, some of that risk should stay with the GC, and some of it should be passed on down.
And it is always negotiable, and everybody wants to fine tune it. But the fundamental intent of that one example is not negotiable from an owner's perspective for the reason you point out. I'm not in the back seat. I'm not even at the back of the bus. I'm in the trailer that the bus is hooked up to, and I can't drive this thing at all.
Right.
And so if somebody breaks something, or if somebody finds something that is broken, and now it's not in your scope to fix it, but it will be your work to fix it, and therefore it's an ad. I need to know, and I don't want to know 6 months from now that you did it 5 months ago.
Exactly right.
And so that becomes a negotiation of that kind of language. But the fundamental intent is to say there isn't anybody who knows more about what's happening out there than you and the GC.
Right, working together on that.
We don't care how, but between you two knuckleheads, if you don't tell me something within some prescribed period of time, you've given up the right. And almost everybody will say, well, 15 days, it should be 50 days, and somebody will say, no, I think it should be 10. And it probably, I would say, usually lands between 15 and 25 days. And it's when you first know of it.
Right. What's reasonable, exactly. So in fact, I don't mind those clauses at all in my contract. I think that we're all, I think what's the word that's used in labor compliance, we're severally and individually, individually. Both and together. We are responsible for making those kinds of things happen. So general contractor working with subcontractors to notify the owner when anything is going to change relative to cost or time. That's why you put that in their contract, and that should obviously flow down. And there shouldn't be any ambiguities in that, right? That should be very, very clear.
Right.
And so the same time frames that you gave the owner should come to or to the general contractor should come to the subcontractor as well. And they should be held accountable for that. I do believe that. So.
Now, I have seen where a contractor got in trouble because they didn't do the certain things, and it was really they're the ones who didn't do it. But they do have some flow down in their subcontracts. I can think of one job in particular where they they were even more broad than our attempt. They basically said whatever's in the prime contract, you're obligated to it, just as if like you had signed the contract.
I've seen those.
And these subs, signed this agreement. Right. And so when this contractor got into trouble and it had a real cost impact, their response was to notify all of the subcontractors. Basically, I'm in trouble because I didn't do this because you guys didn't do it. Now, it may have been only you.
Right.
Or it may have been somebody else. But their notice goes to all of the subs and says, you're all going to chip in and you're all going to pay for this.
Because this is what the contract clause says.
I'm in breach of my contract over this clause, and you all have to cover me.
Right. Now, I can't really speak specifically to how the courts would deal with this because I haven't been in that scenario.
I haven't either.
But it just seems to me like if that did go to litigation, that there would be some kind of consideration about the spirit of this clause as opposed to the letter of this clause. I think there would probably be, in my humble opinion, some admonition from the judge. There should have been more specific language as opposed to this broad language, right? But then I think it would probably boil down to what was the spirit.
Right.
Did the intent, was the owner's intent to make sure that a subcontractor would have to, fall out of my trade was underground wet utilities. So did the owner really intend that I would have to hire carpenters to come in and build the building if, nobody else did that? And I don't think that's what the owner meant.
I don't either.
But I honestly believe that the owner probably said, hey, you know what? If there's some underground that needs to be done, you're going to do it. And even if you missed it or it was added later on, you're going to work through all of the nuances, the negotiations necessary to get everything that is an underground wet utility built for my project.
Yeah. I'm going to take a real saintly position here.
Of course you are.
In that as the owner, I am mostly worried about the subcontractors because you guys are the salt of the earth.
Aren't we though?
And make it all happen. And I know you're going to be contracting with a general contractor, and I apologize for that. But that said, certainly for me, and I think for a lot of owners and or attorneys representing owners in terms of the intent of the flow down, they do put this into the contract with the GC with a real hope and intent that it gets communicated to the subs.
Right.
And there's always a real fear that it doesn't.
Right.
When I get a chance to look at subcontracts in an open book kind of scenario, the first thing I do is I look for flow downs.
Right. And you want it to stick. You want it to have some teeth.
I do.
So you're not interested so much in the broad brush spirit of the clause as much as you are in some specifics. You would want to see the flow downs be able to be stuck to the subcontractor.
Right.
And I think for the most part, the subcontracting community really doesn't have a problem with that.
I wouldn't say stuck to the subcontractor. I would like to know that the subcontractor of their own free will agreed to and negotiated to some reasonable terms.
Well, in that case, we wouldn't even need a subcontract, right? Hey, come do what you guys know how to do. Let's just get her done.
That's true. But we do.
Kind of wrapping this up a little bit, I suppose, best practices for subcontractors and for general contractors, actually the whole team. What do you think some of the best practices should be for dealing with flow downs?
First and foremost, if there are flow downs that are dealing with specific performance or topics, there is going to be negotiation between the owner and the GC. Now, that GC, more than likely, is going to negotiate a position without dealing with any of the subcontractors.
Right.
Many times, this contract is months before that contract.
Yeah, absolutely.
And you had brought it up. I would negotiate against that. I would hope that as a subcontractor, you don't just take whatever the GC is given, right? I would expect there to be some negotiation. It's okay most of the time.
Paint this red and you've got my number.
Right. Exactly.
Yeah, exactly.
Right. Now there are some GCs who have a position of there's no way but my way, and if you want the
work
job,
for me,
you're going to take it.
Exactly.
And if you don't,
and there are many subcontractors who will sign those contracts and put the contract away,
and they'll just hope.
And they hope. And the only time that contract ever comes out and sees the light of day would be in the event of some struggle or some issue that came up and end up with some kind of a dispute.
Right.
And they'll look to see what the contract says about resolving that dispute. And I happen to have worked for subcontractors who did not have that as their model. Every subcontract was carefully negotiated.
Right.
And the idea of that, and I think best practices actually would say that find those flow down provisions, see how broad they are created, how they are stated, and work with your general contractor to clarify the language of those flow downs so that it is completely reasonable.
Right.
It's not like the subcontractor is trying to get out of that because they know that it's falling on them. It is their responsibility. But let's just delineate what in the bulk of that flow down would be the precise responsibility of an individual subcontractor. Right. You mentioned it at the outset of this. Sometimes it ends up being kind of a laziness on the part of all the parties because it's just easier to take the legalese that has been created by an attorney, flow it down and say, no, we can't touch it because it's a flow down legal requirement of the owner.
Right.
And then there might be somebody at the owner, that would be you, as construction manager, sitting in that place saying, no, we're not going to let you manipulate those words because our attorney says we can't.
Right.
And that's usually something that we understand at the subcontracting community as, okay, yeah, that's good for you to say, but in practice, we can have a contract that says whatever we want it to say as long as we can get our general contractor to agree to it. And if you're going to lean on your general contractor, they'll just have to go somewhere else.
Right. Right. So, for an owner, best practice flowing down ownership or their attorney or their CM should understand that just because you have an agreement with the GC doesn't necessarily mean that the GC's agreements to the subs are going to mirror what we're agreeing we want to do. So you should be of a mind that there are certain key things that you would want to specifically say to your GC, this is a flow down. We want to make sure that everybody working on that site understands these 5 things are critical, and they will move to them. Mm-hmm. If you're a project manager for a GC, just like with the sub, you should negotiate with the owner back and forth. If it's an attorney-driven document, my guess is that the owner's position is going to be pretty tough, and that's your only time as the project manager or owner of a GC business to maybe make it more reasonable. And I have had many times where a GC has said, I'm not opposed to that. I could, like, let's say liquidated damages or something like that.
Oh yeah, LDs is another thing. Right.
I could deal with that, but I can't get a sub to deal with it. And the LDs, I will be making a flow down. Mm-hmm. I may acknowledge a different LD with that sub, but I'm first going to say my GC's obligation to the owner is this for liquidated damages. Your obligation to me will be the same, or it will be, I'll cut a separate deal. Right. But many times that GC will say, I can't pass that to a sub. They won't do it. Right. If you want subs on this job, that clause can't go down there.
And because when we get the red pen out, we look at those clauses and we'll say, all right, so you don't want us to necessarily mess with that clause. Okay, leave that clause in place, but you have to accept my attachment to this contract, which in essence scratches that out and replaces it with this language. So there will be exemptions. There will be the addendum, let's say, to the contract or an attachment. So one of the things that we worked hard for as a subcontracting entity would be to negotiate in good faith with any general contractor that we were going to do business with. We would negotiate against their standard form agreement. We would get that in our hands. We would say, regardless of who your owner is and what they're passing on to us, here's what we can live with. And so before we would even get our first job during the estimating process, our estimators would be over there trying to negotiate, or our principals of the company would be trying to negotiate those eventual subcontracts, and they would already have these attachments in place. So the general contractor would look at that as, oh, that's the XYZ subcontractor attachment that must go onto every subcontract. That attachment would have all the exclusions and all of the terms of the contract that needed to be revised for their sake. So now we're coming in a, I would say, a more fair-handed way. It's not a broad brush at all. We'll accept all the flow down reasonably within our scope of work. No harm, no foul.
Yeah, the person, thank goodness, with the heavy lifting is not here. So
yeah.
we don't get to watch him cry. But the GC in my mind has the heavy lifting.
He does.
with flow downs.
Absolutely.
If you're a GC and you're a project manager and you don't really know what you're agreeing to, and you don't know what your subs are going to agree to, you could negotiate with an owner and take on obligations that you'll never be able to pass to a sub.
Right.
And in turn, you then, whatever you've cut, are going to have to negotiate these terms with the subs.
Right, exactly. And so as a sub, I completely buy into what you just said, because when they come to a point where they say, well, I can't pass that on to the subcontracting community that I have in this project right now, we say, well, then just hire a different sub to do that thing, to take care of that issue. You can't do it yourself, but there are other people out there who can, a consultant, an attorney, another subcontractor that can fill in that scope gap. That's not my responsibility to do that. That's your responsibility to do that. So, Jim, it's too bad you weren't here today, buddy, but
do better, man.
I know, right?
Please do better.
I know.
So I think that, anything else to say on flow downs?
No, I think that's
We've got
it.
notes just in case.
Yeah. Well, again, I think best practices, just make sure we communicate, we negotiate strong, we have a good working mutual respect for the various parties of the contract, realizing that it's not just a two-way street, it's a three-way street,
right.
And sometimes even a four-way street. And so we have that mutual respect. And you can't have holes. We understand the owner. You can't have holes in the coverage.
Right.
And so we should all work toward that.
I'd say, kind of in closing, big picture for anybody out there who hasn't really looked at contracts yet, or is just starting to see contracts, or having to deal with construction contracts between owners and general contractors. These are, it's not subtle. I mean, the worst case scenario is there's a sentence in the contract that says everything in this contract will be incorporated into the subcontract. That's destined to fail, right. But it could be there, and or it will identify some very specific things that need to flow through. If there is no language in the prime contract, the contract between the owner and the contractor, that says anything about flow down, nobody's obligating anybody to flow down. But more and more of the contracts have some kind of a flow down language. So,
and one of these days we should invite an attorney and we'll get their opinion of this.
Yeah, I'd like to see an attorney and a GC get along.
Just battle,
yeah, we can do that. So,
all right, here we are.
This is 2 of 3 gigs, and
3 gigs minus 1.
Minus 1. Yeah. We're short a gig. Be sure and look for our next topic. And hopefully you learned something about flow downs.
And I guess we're supposed to say like us and follow us and look for us on your favorite.
That's right.
Where your podcasts are
right.
delivered.
And buy all of our merch. Well, we don't have merch.
We don't have any
we?
merch.
No, never mind. So don't buy it. It's okay.
Oh, I mean, what are we going to get? Like a pair of glasses?
Oh, we could get some coffee cups.
I guess we could. All right, we're out.
Bye.